Mary Beth Gettens, Managing Attorney with Gettens Law.
Today's topic is frequently asked questions about HIPAA business associates. There is a lot of buzz about business associates. Who are they? Are you liable for your business associates? Do you really have to sign a business associate agreement? The Department of Health and Human Services on its website maintains a list of frequently asked questions which provide the answers. Take a listen. Is a covered entity liable for or required to monitor the actions of its business associates? The answer is no. The HIPAA privacy rule requires covered entities to enter into written contracts or arrangements with business associates which protect the privacy of protected health information. But covered entities are not required to monitor or oversee the means by which their business associates carry out privacy safeguards or the extent to which the business associates abide by the privacy requirements of the contract. Nor is the covered entity responsible or liable for the actions of its business associate. However, if a covered entity finds out about a material breach or violation of the contract by the business associate, it must take actions to cure the breach or end the violation, and if unsuccessful, terminate the contract with the business associate. If termination is not feasible, the covered entity must report the problem to the Department of Health and Human Services. Okay, here's the second question. Is a covered entity required to have business associate agreements with technicians such as plumbers, electricians, or repairmen who provide repair services in the covered entity's office? No. Plumbers, electricians, and repairmen do not require access to protected health information to perform their services for the covered entity's office, so they do not meet the definition of a business associate. Any disclosure of protected health information to technicians would be limited in nature, occur as a byproduct of their duties, and could not be reasonably prevented. Such disclosures are incidental and permitted by the privacy rule. The final question. Instead of entering into a contract, can business associates self-certify or be certified by a third party as compliant with the HIPAA privacy rule? No. A covered entity is required to enter into a contract or other written agreement with the business associate that meets the requirements of the HIPAA rule. At the end of the day, if you contract with somebody, they use protected health information to do the job you hire them to do, a business associate agreement must be signed. A message to service providers. If you prevail yourself in the health industry, use protected health information, you have to sign a business associate agreement or you can't do the job. For more information about what is and what must be included in a business associate agreement, read our blog at www.gettenslaw.com.
Again, this has been Mary Beth Gettens. I want to thank you for listening. Hopefully that's been helpful.